Okay, what does the law or case law say about written statements by school administration um, and redirecting unrepresented parent to the school district's lawyer? As in, please don't contact any member of this administration or the school board about this matter again. Call attorney Howe. Okay, now when you say unrepresented parent, it sort of makes me think that you have an active due process case. Because that would be the only time when we would use the term unrepresented parent. The reason being is that you're an equal member of the IEP team. So you have the school district members, but then you have the parent, and those are equal sides. I don't care how many people the school district has participating in the IEP meeting. It is still a 50-50 process. And the goal is consensus, not majority rules. And so in that respect, you're neither represented or unrepresented. You are a valuable member of the IEP team with a voice, with input, and with the ability to advocate effectively for your child. And if there is not consensus, if there is a disagreement on the team, then of course those are the things that then trigger the natural safeguards to where you can hold the school accountable. And that can be done through a state complaint, the different process than due process. A due process complaint where there's an assigned administrative law judge or hearing officer. And in that case, yes, if you don't have a special education attorney backing you up, at that point, that's when you would be considered an unrepresented parent, acting pro se, okay, which is a Latin term, all right? So the unrepresented parent at that point, yes, would naturally be redirected over to the school board's attorney, which, is there any case law against that? No, because at that point you've triggered a legal process through your filing of due process. And at that point, because there's a judge, there's going to be procedure, there's going to be legal requirements, deadlines, timelines, in that setting, it can seem and appear like an insurmountable, confusing process. It's not. It looks complex, and it's easy for me to say that because I'm an attorney. At the same time, I can see where it would be extremely stressful for parents trying to navigate that process. And, but at that point, yes, the school district has the right to use an attorney at that point. Anytime before that, there's not a prohibition against it. It just sort of is standard practice, or has been sort of standard practice, not to have attorneys present in, let's say, IEP meetings. But once you file a due process, then yes, the school district, except for the resolution meeting, if the parent isn't represented at resolution, and that's the first meeting after you file, that has to happen within the first 15 days. If you are not represented, then the school district doesn't send their attorney to the resolution meeting. This is the initial meeting the school's required to have. Now, some will sit there and waive it and go, we're not going to, I don't recommend that. It's sort of stupid. You don't have a right to resolution. The school district has a right to a resolution meeting. Most will participate in it. And, that's sort of where they catch parents, as well as if there's not showing up in good faith or whatever. You got to be careful about that. But as far as being willing to negotiate and work through the issues, outside of that resolution where it specifically states in the law that if you don't have an attorney, they can't have theirs. Outside of that, then yes, the attorney is involved. The attorney is the one that you're dealing with. When you have the conference calls with the hearing officer, it's going to be the board's attorney on the other end, by and large. It doesn't mean that the school can opt out of paying their attorney. In fact, I have cases now to where I am involved, and I will file these, and the superintendent in some of my cases will just say, yeah, we're not going to pay our attorney. I'll deal with Galini directly, and then save the district some money by not having to pay their board attorney for something that the superintendent feels like he or she can accomplish with me by working directly with me. That is their prerogative, okay? Once they make that pronouncement that they're acting as their own attorney, then I don't make a big stink about it. But I live in a different world because I got to be real careful about who I communicate with and whatnot because of the ethical requirements on me as an attorney. But as a parent, being unrepresented, yes, the school can sit there and say we are represented, and because we are represented, and we are in a legal process, then they can sit there and ask you to go through whoever their attorney is during that process. If you're just in an IEP setting and you haven't filed anything and they're still directing you over to their attorney, no, that's inappropriate. And how do you resolve that? Office of Civil Rights, a state complaint to where it's a different process, or I guess you could file a due process. I don't really necessarily think that amounts to a denial of FAPE, but it would be better suited to deal with through a state complaint process or with the Office of Civil Rights. That's if you're not in a legal setting and they're still directing you over and not communicating freely with you. Because quite frankly, I think there would be grounds that it's denying your right as a parent to full parental participation by having an attorney communicate and be the conduit of communication. That isn't what's anticipated. That's not what's laid out. That's not the intent behind IDEA. IDEA, the intent is to have the parent and the school district staff work together collaboratively to reach consensus on behalf of the child in developing an IEP.